I'm James Swartz, managing attorney at Swartz and Swartz. So injuries to children, of course, happen all the time. Often minor injuries, cuts, bruises, scrapes. And as parents and caregivers, of course, we know what to do in those situations. However, sometimes injuries can be very serious. And it's important to understand whether those injuries are caused by the negligence of another individual or a business or a government entity. If those serious injuries have been caused by someone else's negligence, you may be able to pursue a claim on behalf of your child. So types of claims for injuries to children, of course, vary widely. There could be car accident claims, defective products, medical negligence. Of course, claims that can be pursued on behalf of children for injuries vary widely. Some of those instances include claims that adults and children both can pursue. So for example, medical negligence, defective products, slip and fall accidents, premises liability, and medical negligence all are categories of claims that can be pursued if the injuries were caused by negligence. However, other claims are more particular to children. So for example, injuries that occur at schools or daycare or child abuse. Very often, injuries occur when children enter onto the property owned by another person or entity. These types of cases sometimes can be categorized as attractive nuisance cases in the law. So what that essentially means is that there is something on that property that children may be attracted to. And in those circumstances, the owner has a duty to make sure that those children are protected from any dangers presented by those items or situations on their property. So some attractive nuisance cases include, for example, swimming pools. Most states require that there at least be fencing around those pools and perhaps other protections to prevent injuries to children and others. Other attractive nuisance cases might include things like ditches or mounds of dirt or products placed near playgrounds. So owners of those properties, again, in many of those situations, have an obligation to make sure that visitors or even trespassers in some instances are not injured due to a defective condition. So for premises liability cases or attractive nuisance cases involving children, there are certain requirements and evidentiary hurdles to overcome in order to pursue those claims. Some of those requirements of proof to pursue such claims include that the landowner knew or should have known of the unreasonably dangerous condition, and knowing of that condition failed to take reasonable steps to remove that danger. In order to pursue claims on behalf of children, typically a parent or guardian will bring a lawsuit on behalf of their child. However, for some cases, strategically or for other reasons, a guardian ad litem might be appointed by the court to pursue those claims on behalf of the child. As in all cases, claims brought by children have time limits. So typically, there's a 3-year statute of limitations, for example, in Massachusetts, to pursue personal injury claims. When injuries occur to a small child, however, that child may still pursue claims for 3 years after they reach the age of majority. So it's important to understand what those time limitations are with respect to claims on behalf of children as well as adults. If you have questions about claims of negligence involving your child, contact Swartz and Swartz.